The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning. Welcome to council and to those watching on the live stream. Council, we do look forward to your arguments this morning. I would now ask Mr. Doug Shima to please call the docket for the 11 o'clock docket.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Friday, February 5th, 2021 consists of one case. Appeal number 121516, State of Kansas versus Jonathan D. Blevins, Jefferson County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we're ready to proceed.
Thank you, Mr. Shima. Council, would you please state your appearances?
Mr. Blevins appears by Merrill Carver-Allman, Capital Appellate Defender, and we're here and ready for argument.
May it please the court, the state appears by Assistant Solicitor General Natalie Chalmers.
Thank you. Ms. Carver-Allman, you may begin with your argument.
Thank you, Justice Lukert. This is a case about prosecutorial error and other trial errors building on each other to ultimately deny Mr. Blevins a fair trial. In March of 2018, Mr. Blevins, Ashlyn Hemmerling, and Taylor Sawyer were driving around together in Lawrence and in the Lawrence area. Mr. Sawyer was high and as a result was suffering from some paranoia. So they decided to drive out to Perry Lake, let him smoke some marijuana, look at the stars, hopefully calm down a bit. And there were technically, I think, 3 final stories, but really 2 credible stories that were presented to the jury about how they got to that point and what really happened next. And one involved Mr. Blevins shooting Mr. Sawyer at Ms. Hemmerling's request and at her direction. The other was that Ms. Hemmerling herself was the shooter and Mr. Blevins was kind of just there and had only initially tried to take the blame in order to shield Ms. Hemmerling, who he viewed with sort of a big brother protectiveness. Ultimately, however it happened, very sadly, Mr. Sawyer was shot in the head twice and he was killed. Mr. Blevins was charged with first-degree murder. And really the heart of the question that the jury had to decide was whether Mr. Blevins was responsible for the murder or if it was Ms. Hemmerling. That was, apportioning responsibility between those two was the heart of the case. Now, we've raised more issues than I can possibly get to in 15 minutes. So it's my plan today to really focus on the prosecutorial error and the instructional error and how both independently and really added together, those errors work to deny Mr. Blevins a fair trial. So I'm going to begin with the prosecutorial error. And just as a housekeeping note, as I'm sure the court is aware, Ms. Chalmers filed a motion, I think, a few weeks ago to add an exhibit to the record that tended to show that one of the prosecutor's statements that we alleged wasn't supported is actually supported. And I probably would have filed something, but we were so close to argument anyway, it just didn't make much sense. But we would withdraw that part of our argument. I think Ms. Chalmers has shown has proven her case there. But there's still a lot of prosecutorial error to talk about here. And I'm going to start with this misstatement of law, and that's this stream of inevitability statement. I don't want to go so far as to say that the prosecutor was saying he was guilty because he was there, because that's not accurate. But there was no acknowledgement that he couldn't just be, her chauffeur for the evening driving her around. He had to actually be helping with intent to kill. So we're arguing that that was a misstatement of law. There are also some issues where the prosecutor is stating personal opinion and commenting on the defendant's credibility. And I don't know that I have much to add to the brief on those other than to say that just a couple of, the state believes the evidence shows some statements like that you see good prosecutors make to get out of this type of error. That would have gone a long way here. And I think the state's even conceding that the I believe statements were error. And then, of course, we have several misstatement misstatements of facts that that go into this as well. And I don't think any of those are critical on their own. It's just really the whole picture of it together. This closing argument had a lot of problems, I think. And I'm happy to answer questions about that, of course. I was thinking I would go on to the instructional error and then talk about reversibility sort of in a cumulative way, because I think that just makes more sense. On the instructional error, of course, we're in clear error land, and arguing that the instruction was not factually appropriate. And our argument here is that either Mr. Blevins was the shooter, and maybe Miss Hemmerling aided and abetted him, maybe she didn't, not really germane, or Hemmerling was the shooter and Mr. Blevins was just there. But those are the two stories the jury had to pick from. And the state says, well, they could have believed a little bit of this and a little bit of that, and has a case that they cite to support that. But the case that the state cites is really discussing the issue in a prosecutorial error context, not in a sufficiency of the evidence context. So we would argue that that's not terrifically supported there. As to reversibility, the tests for cumulative prosecutorial error and cumulative error generally are pretty close together. So that's kind of why I want to talk about them sort of in total. We're talking about totality of circumstances. We're talking about whether the error impacted the verdict and the defendant was substantially prejudiced and denied a fair trial. Overwhelming evidence is, of course, a consideration, but it's not the whole test. And, as I said at the beginning of this, the real question in this case was not whether Mr. Blevins was there. We know he was there. We know Miss Hemmerling was there. So the physical evidence here is not that helpful in deciding what was the real question in this case, which was who really was carrying the blame. And one thing that the state doesn't note in its summation of the evidence is that Miss Hemmerling had the motive. And we haven't mentioned it yet today, of course. But Miss Hemmerling was mad at Mr. Sawyer because he had assaulted her and her mother, and I think possibly sister as well. So she was the one who had the motive here. She was the one who had strong evidence to want this man dead. But in summary, our argument is that all of these problems joined together. They lowered the burden of proof to the point that really mattered here. And created a situation where the jury could have convicted him just for sort of being there and chauffeuring her around, even if he didn't really have an intent to kill. So, if there are questions about any of the other issues, any of the issues I've presented, of course, I would be happy to answer them. But I think that is those are really the points that I wanted to make today.
Are there any questions? Thank you, counsel.
Thank you.
Ms. Chalmers?
The state admits that the prosecutorial closing argument had, well, not even very many mistakes, but at least the one mistake about the I believe, although that was so limited and I don't know, could have easily been corrected. There is no way the jury wouldn't have reached the same conclusion. Any error that this court finds is not reversible, either accumulated or individually. The state actually would like to focus more, unless this court has questions. Yes.
Counsel, do you think it would have been an appropriate statement if it had been said, I believe the evidence shows?
Yes, Your Honor. This court has kind of created an issue where I think people just naturally say, I believe. It's something I even said in my argument the other day without thinking. So prosecutors do that, and they need to learn to tie it to the evidence. I think one statement was tied to the evidence. The other one, if viewed in isolation, isn't as tied to the evidence. But essentially the prosecutor was just saying there's the jury's decision to decide who is credible. There's nothing wrong with that. Just the way he stated it wasn't perfect, but it wasn't error that requires reversal here. If there are no further questions on that issue, I, of course, would be happy to answer any questions. The state is more concerned, honestly, with the defendants raising the claim of prosecutorial error during sentencing. The idea that the state can't just argue the facts as it viewed it. The idea that the state can't say that, the state's theory of the case was essentially that Blevins was the killer. He shot Sawyer. And the idea that the state can't say that during closing argument is entirely unsupported by any case law and should not be adopted by this court. With the withdrawal of the issue that I wrongfully conceded, I don't really have anything else to add unless this court has any questions. I think that this case is clear that no reversible error occurred, and this court should affirm Blevins' convictions and the sentence.
What do you make of the stream of inevitability argument and the potential impact that might have had on the premeditation intentionality?
The stream of inevitability argument was made immediately after the prosecutor said, here is the law on aiding and abetting. The jury instructions told them the law on aiding and abetting. If you mean the stream of inevitability as to aiding and abetting, I'm sorry, if you mean the intent as to aiding and abetting, I think that the prosecutor's statement immediately before and the jury instructions make it clear that the defendant would have had to have share in the premeditation intent to commit murder. So I think that statement is actually kind of confusing to the jury, what the stream of inevitability is. What the prosecutor was trying to argue is if Blevins picked out the place to commit the murder and provided the weapon after they'd had a discussion about killing him, it is reasonable to assume that he intended to aid and abet. If you're asking about the actual conviction and the stronger theory of the case, which is that Blevins himself is the shooter, the statement just doesn't matter. There's ample evidence of premeditation. He drove him out to a secluded spot. He shot him 2 times. He talked about in his confession that he knew 15 minutes before that he was going to kill him. He talks about disposing the body. And there's overwhelming evidence of premeditation in this case based on Blevins' confession.
Are there any other questions? Thank you, counsel.
Thank you.
Ms. Carver-Ullman, you reserve 3 minutes.
May it please the court, just very briefly, Your Honors, what I hear Ms. Chalmers saying is, this is what the prosecutor said, but this is what they really meant. Well, the jury heard what he said. So, we don't look at intentions anymore post-Sherman. So, we have to look at what he said, not what he might have meant to say. And just to briefly touch on the sentencing prosecutorial error, and actually, I want to look at some of the other bits of that. Actually, we're talking about the state saying its theory of the case in one way, but we don't know that he was convicted as the principal. We can't know that because of the aiding and abetting instruction that was given. And the judge was there, and I understand that. But there's something uncomfortable to me, and I know this isn't what Ms. Chalmers means, absolutely, but there's something uncomfortable to me about, as long as the judge was there and he knows what really happens, you can misstate facts to a judge, and that's okay. So that part of that kind of troubles me.
Is it misstating facts or just characterizing the facts that you believe are supported? Was there really a misstatement of facts, or just the state's theory was supported with evidence, wasn't it?
It was, from a sufficiency standpoint, of course, yes, it was. But and the record will show, I can't tell the court, the precise words that the prosecutor used standing right here now. But to the extent he was saying he was convicted because he was the shooter, that's wishy-washy, because we don't know that the jury's verdict showed that. We also had the comments that he started his felony record when he was 15 years old, things like that. And I think the state's splitting some hairs there about that was misconstrued somehow. I think it's pretty clear that he started his felony record when he was 15 years old, and he's participated in the drug and gun culture since then. There's some continuity assumed there. But the record will show what it shows on that. And unless this court has further questions, we would just ask that you reverse Mr. Blevins' convictions, essentially for cumulative error.
Any other questions? Thank you to both counsel for your arguments. The court will take this appeal under advisement. We are